thing we thought we'd start with is talking a little bit about what's patentable subject matter, and I'm going to flip it over to Rana. We'll just pass the mic back and forth.
Thanks, Don. So we thought we would discuss patentable subject matter since this is one of the key requirements for patentability. Basically, whatever you invented or you think you invented, is it patentable subject matter? Because you can't just go ahead and patent anything you'd like. And according to the statute that determines patentable subject matter, 35 U.S.C. 101, there are 4 categories of patentable subject matter. First one is a process. And a process, you know, when you think of biology, it's really a method of doing something. A method of treatment, a method of diagnosis. Typically, that's what we'd call a process. The second category is a machine. It's probably not as relevant to biotech, but you know, definitely that's another category of patentable subject matter. The third category is manufacture. Sometimes we call it article of manufacture. It's basically anything, an object or just an article that is made through some type of manufacturing process. So you can think of a chair, you can think of a glove, you can think of, you know, an article of clothing. And when you think of biotech, I mean, you know, genetically engineered bacteria, genetically engineered animals, organisms, sometimes those would fall under the article of manufacture because, you know, they're actually synthesized through a particular process. And finally, the last category is composition of matter. And composition of matter is just, it's an ingredient. It could be a drug, a small molecule, an antibody. This is what would fall under the category composition of matter. So one would think that, okay, that's pretty straightforward. I can just go ahead and, you know, patent any one of these things. This would be considered patentable subject matter. As you can see, this is really a historical decision by the Supreme Court in 1980 as to, you know, amongst living organisms, what is really considered patentable. Not everything is patentable, because anything that exists as is in nature, say a plant, it grows in your backyard, you can't just go ahead and patent that plant because there's nothing novel about it. You didn't really invent anything about that plant. It's a product of nature. Products of nature are generally considered non-patentable. And that's how they were always considered until this case came along. And this case is about a scientist at, I think it was working at General Electric. He developed a bacterium that was capable of breaking down crude oil. So it was a genetically engineered bacterium, and he tried to patent it. So the patent office basically told him, no, this is a living organism. You can't just patent it. That's not patentable. It exists in nature. Basically, you know, this eventually went to court, and the Supreme Court thought otherwise. Basically, what the Supreme Court said is, you know, this is a very famous quote we like to use, anything under the sun that is made by man is patentable. So if it's just a bacterium, you go ahead and you isolate it in your backyard, you take some soil and you, oh, I found this bacterium, probably you won't be able to patent it. But if it's a genetically engineered bacterium, you actually did something with it. You created a new organism that was not present in nature, then this would be considered patentable subject matter. And for the longest time, really, the patent office, the courts would consider anything that was, you know, you said, made by man, any living organism made by man to be patentable, any kind of, you know, methods of treatment, methods of diagnosis. For the longest time, we didn't have, you know, much trouble getting those claims allowed as long as they're considered novel, non-obvious, enabled. Those are the other requirements for patentability. Until recently, this case, the next one. All right, so this is the second decision I was mentioning, and I know you probably read about this in the newspaper. It came out last year. Big decision with regards to you know, whether genes are patentable. So you probably, I don't know if you've heard of Myriad. This company discovered the location and sequence of 2 genes, BRCA1 and BRCA2, that indicate when you have certain mutations in those genes, this would indicate a predisposition for women to have develop, breast and ovarian cancer. Angelina Jolie was very vocal about this. She actually had surgery done because apparently she had the mutation. So there was a lot of talk about, Myriad, the company, and this particular case. So Myriad actually had patents directed to the BRCA1, the BRCA2 genes. Basically, their claims were very simple. They said it's just basically an isolated DNA that encodes, that doesn't even encode, that has a sequence, whatever. And that's the particular sequence that they had. These patents were challenged in the district court, and the case made its way to the Supreme Court, where the question was, are human genes patentable? Because all Myriad did was just isolate those genes and patent them. What they did do also, they had claims directed to cDNA, so they had those additional claims as well. And what the court determined was that naturally occurring DNA, even if you isolate it, it's not considered patentable because you're not really doing anything with it. You're not incorporating anything novel into it. You're not changing the sequence. You're not changing its structure or anything like that. You're just pulling it out from the genome, just saying, here you are. This is another gene. However, cDNA, which is considered, synthetic, that would be considered patentable because that's not something that you just find in nature as cDNA. It's usually something you make in a lab. In fact, everything is originally a natural product. Antibodies, biomarkers, everything, proteins. Really, this is what biotech is about. It's really taking, whatever's in our body and using it to treat diseases or diagnose diseases. So with these two decisions, say you can't patent, any natural products unless you do something different with them, and you can't just apply a law of nature. It really creates a challenge as to, okay, how are we going to draft these claims? How are we going to put forward our case for this invention, which is true, we truly believe it's an invention, while abiding by the law and making sure that we put enough information in there and show enough utility and enough differences so we can actually get a patent on this invention. And that's become a big challenge. I mean, these two cases really, we think of it, it's really a lethal combination because when you think you've overcome one, you're dealing with the other and vice versa. So there are ways to do this. There's a lot of talk. There are a lot of articles that were written, a lot of seminars as to how we can bring forth, this invention and draft good claims that would make it clear that this is not just applying the law of nature, and this is not just any natural product. It's much more than that, and there's something really novel and patentable about it.
Yeah, the more you can tie in something technological, and using that in a really broad sense, whether it's biotechnology or whatever, once you can throw in some details like that, it starts, it makes it much more likely it's patentable. It makes it narrower, but it also makes it patentable. Those two kind of go together. And the more you try to just describe it as kind of a law of nature or a basic correlation between a higher level of this means you're more likely to have that, and it's just sort of a scientific principle, less likely it's patentable. So the secret tends to be to throw some of that technology into your patent description and then try to go after as many different variations as you can and hope you get something that sticks, basically. And so there's a little bit more of just almost like trial and error. The next case really, so I'll talk about that a little bit because it's more my area, but we won't really talk about it very much. It's a software case, but so why do you care about it? What was sort of interesting about it, I think, from a broader perspective, is when the court decided the Alice case, which is really more about business methods, which you hear about is generally not being patentable, but it followed the same analysis that it had done in the Mayo case that was 2 slides ago, where basically it said, and so it kind of enforced that basic principle, which is, it's kind of a 2-step process you should look at. The first one is it a basic scientific principle? Is it something that occurs in nature? Basic scientific principle, like you know, things accelerate at, you know, 1/2 ag whatever squared or equals mc squared. Is it some basic principle? And if you're trying, or an abstract idea, so that's the first thing you look at. So if it's this basic principle, abstract idea, then we go on to the second test, or the second step, and look at, are you applying it in some inventive way? So are you adding something basically non-trivial to the basic scientific principle? And if you add something non-trivial to the basic scientific principle, then at least you're getting over the hurdle of, is it patentable subject matter? So that shows up with trying to patent sort of business methods. Are you doing something more than the basic business method? It shows up in diagnostics, so you're trying to patent more than just the basic correlation between, if you've got a high level of this in your blood, you've got that disease. It kind of shows up in trying to patent genes, right? If you're just taking the gene itself, which is natural, that you can't patent. But if you chop out things and like take the cDNA, and now you've got something a little bit different, then it is patentable subject matter. So that even though this case is completely different in a way from Myriad and Mayo, they're all looking at sort of the same principle. And much as we've tried to talk this all through, the law is very unsettled at this point, and where the lines are, nobody, I don't think anybody really knows, and it's going to take more cases to figure out where this plays out. And I guess the next slide, which sort of gives the Patent Office's guidelines, are a little bit helpful, but not much more than that. So, whoops. You want to go back?
Sure. So basically, actually, after the Mayo case came out, the PTO's challenge is always, okay, once there's a decision that comes from the Supreme Court or even the Federal Circuit or any court related to this, what do we do about it? So they have to establish rules, they have to establish guidelines to see how they should now be examining patent applications. So there is actually more than one set of guidelines that were issued by the PTO in connection with patentable subject matter in the life sciences. This is the most recent one, which was issued just a couple of months ago. And basically they're saying, okay, you have to consider these three questions when you're looking at claims. First of all, do they fall into one of these four categories that are deemed patentable subject matter? We talked about process, machine, manufacture, or composition of matter. And if they do, the next question would be, does the claim reciter involve one or more of these judicial exceptions that we've been talking about? The abstract idea, the law of nature, the natural principles, natural phenomena, natural products. And genes, proteins, all of those, of course, would fall into that category. So the most important question becomes the third one. Okay, now that we've determined that they fall into these judicial exceptions, is there something significantly different about them? And here we're going back to this. You have to make your case to the PTO to show that, both your application and in your claim specifically, that this is not just applying the law of nature. This is not just some natural product. There's more to it than that. One way of doing this, and I know I've done this with some of my cases, I have a portfolio that deals with methods of diagnosis. Those applications were drafted way before the Mayo case came out. And, patent law, once you draft the application, you can't really add anything to it. If you want to keep it as is, you can file a new application, but you can lose priority. So if you really want that priority date, you're pretty much bound by what's in your original application. So my challenge was to see, okay, I get these rejections from the PTO to these methods of determining whether somebody has, kidney disease or whatever. But, once again, looking at these different levels of this biomarker in a blood sample, what do you do? One suggestion the PTO has is, if your claims include, additional steps or elements that are not routine, that are not conventional, that incorporate something different, something novel. So one example we had was if you use a particular antibody, some new antibody that you developed in this particular method, so that would be very different, then you could probably patent that method. If there's something very particular about the method itself, some some reagents you use, some kind of methodology in there that's not routine or conventional, because you're adding these different steps, that might be patentable as well. Another thing that has actually been done, and there are at least, I can think of at least a couple of patents that issued that dealt with, rejections under Mayo. One way to do it is to incorporate a method of treatment into your diagnostic claims. So you'd say it's a method of treatment, using this and this drug, and within the treatment claims, you incorporate a method of diagnosis. Once again, it has to have something different about it, but that's one way of actually getting your claims patentable, because you're not just applying a law of nature, you're going beyond. So this is, one suggestion the PTO has as to how you can get these claims, how you can patent these claims.
So one way you might look at it, sort of a little bit generically, but at least I find it helpful, is if you try to patent the fact of doing something, then that's very hard to do. But if you patent your particular way of doing it or how you do it, much more likely that that's patentable. And people resist doing that because they want to patent the fact of doing it. So it covers however you do it, doesn't really matter. And the courts are not comfortable with that. But when you start saying your way of doing it, and obviously you still try to do it your way, but as broad as you can, then you start getting into something that's much more likely to be patentable.
And when you're trying to patent, say, a composition of matter, a new plasmid, another way of getting your claims allowed is to show that, once again, this is not just a product of nature, this is something that's markedly different. For example, it has a different structure, you provide evidence, you can provide a declaration from an expert saying that you will never find this type of structure in nature because, this was something that was made in the lab. Once again, the hand of man, that, quote that we like to use. Or that, for example, it may have a similar structure to what's in nature, but it has a totally different function, totally unexpected function. So basically, you have to really make an effort to distinguish your claims that deal with either, a law of nature or product of nature, distinguish it from what is the typical law of nature, product of nature. You need a lot of support in your specification, but you also have to have very good claims that are well drafted and that really bring out these differences.
The next one is, I don't know, maybe that's sort of ends up being of more interest to the patent lawyers than to the rest of you, but we think it was still kind of interesting. Patent claims are supposed to be definite. You're supposed to be able to read the claim as someone in the field and understand what's covered and what's not covered, and know whether you have to do something differently or not. I mean, that is certainly one of the purposes, and if patent claims aren't clear, then the system kind of falls apart because nobody knows what they can do and what they can't do. So from a patent law perspective, the question is the claim definite or indefinite? And if it's indefinite, it's no good, and if it's definite, it's fine. The appeals court had for a long time said that claims were sufficiently definite unless they were insolubly ambiguous, which is almost impossible to meet or not meet that standard. So very much favored patent holders, and you could have claims that people could, really honestly say could mean two different things, but as long as you could resolve it under the court standard, it was still a valid claim, which is great if you're a patent holder and kind of bad if you're someone trying to develop a competing product because you really don't know whether it's going to be covered or not. The Supreme Court just this past term ruled that that's sort of that standard goes too far, and what you need to look at is does the claim inform you with a reasonable certainty as to what it covers? So you're going to say, well, what does that mean? And all right, the truth is none of us know what that means, other than it's more restrictive than the old insolubly ambiguous standard. And so in practice, how much this changes things for most people, probably not a lot. other than it's sort of a reminder to make sure that you really can figure out what's covered by your patent, much more so than before this. But probably for most people is something that only kind of comes up if there's litigation, and for most of us that's way down the road. The other one will, again, probably isn't worth a lot of discussion. It's about induced infringement, which so it sort of requires talking about two different things. When you've got a method claim, say a method for treating someone or for diagnosing something, the appeals court has said for a long time that one party has to do all the steps. So think about it if it was sort of a diagnostic sort of test, and some of it's done by a lab and some of it's done separately by the doctor in the office or something. There's not one party doing all the steps, and then because there isn't one party doing all the steps, there's no one party that's infringing, so there's no infringement, and therefore nobody violates the patent. So the Federal Circuit, the court that handles appeals, sort of has had this as a premise for what's required to meet a method claim. But at the same time, they kind of found that seemed sort of unfair, because people would then, one person would do some steps and someone else would do the other steps, and nobody's liable and the patent becomes worthless. And the way the Federal Circuit sort of got around that was they said, well, you could still be inducing infringement if you induce some of the steps, knowing that all the steps will be done by somebody, not necessarily all by one party. And that went up to the Supreme Court in the, I'm really having trouble with this clicker, Limelight case, which is a technology case. It has nothing to do with biotech, but the principles come out the same. The Supreme Court said, no, wait a minute, you've got this all backwards. If there is no direct infringement, then there can't be inducing infringement, because you can't be inducing infringement unless you're inducing somebody to infringe. So at that point, it sounds like, all right, that's great. That's a great win for the potential infringer. But then the Supreme Court said, so we're not going to decide this direct infringement question about whether it has to be one party or not, but we recognize that that principle is what led to this sort of quirky decision by the Federal Circuit. So maybe you, the Federal Circuit, want to go back and reconsider what you've said, that it has to be one party doing all the steps in order for there to be direct infringement. So the court, this just came down last month. There haven't been any further decisions yet, but it is likely that that will change, because the Supreme Court really, I'd say, invited the Federal Circuit to change what it did, which may make it a little bit easier to find method claims infringed, which makes it a little bit easier if you're a patent holder and trying to figure out how to write the claims. From a patent lawyer's perspective, we've known this for a while now, and we're always trying to write claims that will be directed to one party. But of course, today what's done by one party might be done by two different parties 5 years from now, as the technology changes and the way offices or labs are set up. So probably some implications, something as you're talking to your patent lawyers, you just want to sort of be mindful of as you're just thinking about it if you're using method claims, because those could be really important, and just make sure that you're thinking through who's going to do the steps and trying to focus it on one party as the active party in it. And oddly enough, almost any method can be reworked to make it one party doing all the steps, even if sort of conceptually it sounds like multiple parties do it. So the other thing we want to talk about real briefly is the patent reform, which passed couple of years ago, and over the past year has finally kicked in. And we're just going to talk about two aspects of it, which we think are the most significant aspects. Forget about all the details about what it's called and all. Nobody really cares that it's the Leahy-Smith American Invents Act. But the two key parts to the statute for most people are first to file and then some post-grant proceedings. So in the United States, and the US was fairly unique this way, until the patent reform, it was a first to invent system. So based on whoever invented it first ought to get the patent, and there were some exceptions, but that was the basic premise behind it. The rest of the world was first to file, which was a lot more like the way things are. If you buy a house, you know, you have to record the transfer of the ownership, and the laws were all based on whoever files it first wins. So if I sell my house to you, and then you don't record the title, and then I sell it to Rana, and she records the title in good faith, she owns the house, even though you bought it first. Because it was all based on having a title system that people could look up who owns it and who's first. And the rest of the world kind of worked the patent system the same way, if that analogy holds. Whoever files it first gets the patent because they want people to file for patents. So the US has now switched more, I'll say more to a first to file system because there's some exceptions in here, but largely whoever files first is going to get the patent. So I come up with the idea first, but Rana gets to the patent office a week before me, she gets the patent. So obvious implications for people who are developing products, which is you do want to get to the patent office quickly. Don't go crazy about it, because if you go to the patent office with your sort of half-baked idea, that doesn't really get you anywhere, because it's only your half-baked idea, and what you actually really want to protect is something you evolved over time. But you do want to keep in mind that it is important to get to the patent office first, especially if it's an area where you know or believe there are other people working in the same space or the same area, same ideas. It really does pay to get to the patent office first, because you'll win. There are exceptions if you've published it first or something like that, but we don't encourage you to publish before you get to the patent office, because you can lose rights that way outside the US. So that's sort of the gist of first to file, I think.
Definitely. Yep.
So everything you need to know about the American Invents Act in 5 minutes or less. And then the other one, and we've got a few slides that talk about this a little bit, but is post-grant procedures. And so there had always been ways to challenge patents after they issue. But with the American Invents Act, there are more ways to do it, to challenge patents. These various post-grant procedures, we're not going to get into all the details here, because unless you're in the middle of it, you don't really care. But there are more ways to do it. It's much cheaper than litigation. It's in the patent office. It's much quicker than doing it in litigation. And the standards are easier to meet if you're doing it in the patent office than if you're doing it in litigation. So if you're in court and you're challenging a patent, you have to prove by clear and convincing evidence, which means really likely that you win, that the patent's invalid. If you're in the patent office, it's just a preponderance of the evidence. So more likely than not that the patent's invalid. So how does this play out? It sort of depends on which side you're on. If you've got a patent, then it's just good to know that there's this way that people can challenge patents. If you're developing a new product and you see there's a patent out there, you're potentially an infringer or a patent challenger, it's good to know that there are these procedures out there, because challenging the patent in the patent office might be a good way to clear it out so you can sell your product without infringing the patent, risking being enjoined, something like that. So I'm not going to get into all the details. For this discussion, we could take hours and hours talking about it, but it is, I think, useful to know that there are a number of procedures. Some only work for the first 9 months after the patent issues. Some you can do anytime. but just good to, I'd say, remember that there are many more ways to do that now. They've been more popular among the computer and mechanical technology than in the biotech space so far, but that's starting to change as more of in the biotech space, people are seeing this as a sort of different option for trying to clear out some patents.
Thank you.
Thank you.